Imagine a world where the very ground you're born on no longer guarantees your belonging, where a decades-old constitutional promise could be rewritten by executive fiat. This was the stark reality facing hundreds of thousands of families across the United States as President Donald Trump's administration sought to fundamentally alter birthright citizenship. It was a legal battle that cut to the core of what it means to be an American, challenging a principle enshrined in the 14th Amendment for over 150 years. The stakes were monumental, promising to redefine the future for an estimated 250,000 babies born annually on U.S. soil. The ultimate arbiter would be the Supreme Court, tasked with weighing history, intent, and modern interpretation against a bold presidential decree. The bedrock of this constitutional debate dates back to 1868. In the aftermath of the Civil War, the 14th Amendment was ratified, a monumental step designed to grant citizenship to formerly enslaved black people. Its citizenship clause declares, all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. This language was intentionally broad, aiming to prevent any state from denying citizenship based on race or previous condition of servitude. For decades, legal scholars and the public largely understood this clause to mean that nearly anyone born within U.S. borders was automatically a citizen, a principle rooted in English common law. The expansive reach of the Citizenship Clause was decisively affirmed by the Supreme Court in 1898 with the landmark case of United States v. Wong Kim Ark. Wong Kim Ark, born in San Francisco in 1873 to Chinese immigrant parents who were not U.S. citizens, traveled to China and was denied re-entry to the United States. The court ruled overwhelmingly that he was a U.S. citizen by birth, establishing that the phrase "subject to the jurisdiction thereof" meant allegiance to the U.S. government, not a requirement of parental citizenship or permanent domicile. This decision solidified birthright citizenship for virtually all children born on U.S. soil, regardless of their parents' immigration status, setting a critical precedent that would stand for well over a century. Fast forward to January 20, 2025. On his first day of a second term, President Donald Trump signed Executive Order No. 14,160, titled Protecting the Meaning and Value of American Citizenship. This order represented an unprecedented attempt to redefine birthright citizenship, asserting it did not apply to children born in the U.S. if their mother was unlawfully present, or temporarily present, and the father was not a U.S. citizen or lawful permanent resident. The administration argued that the 14th Amendment's framers never intended such a broad interpretation, claiming modern birthright citizenship encouraged illegal immigration and birth tourism. This directive, if implemented, would have denied citizenship to an estimated 250,000 babies annually. The ink was barely dry on Executive Order 14,160 before legal challenges erupted across the nation. Almost immediately in early 2025, multiple federal district courts issued universal injunctions, effectively blocking the implementation of the executive order. These swift legal actions meant that despite the president's directive, no child was actually denied birthright citizenship under its provisions. A pivotal moment came on July 10, 2025, when a class-wide preliminary injunction was granted in the case Barbara v. Trump, filed in the District of New Hampshire. This ruling, like others, underscored the immediate and widespread legal opposition to the administration's policy, setting the stage for a higher court review. With injunctions stacking up, the case quickly escalated. On September 5, 2025, a notice of appeal was filed in the First Circuit Court of Appeals. However, the legal journey to the Supreme Court took an unusual path. In late 2025, the Supreme Court granted certiorari before judgment, a rare move where the High Court agrees to hear a case directly from the lower courts, bypassing the typical appellate process. This decision highlighted the profound constitutional questions at stake and the urgency with which the court viewed the matter. The nation braced for a direct confrontation over one of its most foundational civil rights, as arguments were scheduled for the following spring. April 1, 2026, marked a historic day in Washington, D.C. Oral arguments for Trump v. Barbara commenced before the Supreme Court, lasting 2 hours. The atmosphere was charged, not least because President Donald Trump himself attended the proceedings in person, an unprecedented event for a sitting president in modern history. U.S. Solicitor General John Sauer, representing the Trump administration, argued that the 14th Amendment's subject to the jurisdiction thereof clause required political allegiance, not mere physical presence. He contended that 8 billion people are one plane ride away from having a child who's a U.S. citizen. Meanwhile, ACLU National Legal Director Cecilia Wang passionately defended the established interpretation, emphasizing the historical context and the plain language of the amendment. The wait concluded on June 30, 2026, when the Supreme Court delivered its landmark 6-3 decision in Trump v. Ibarra. Chief Justice John Roberts authored the majority opinion, which unequivocally struck down Executive Order 14,160. Roberts, joined by Justices Sotomayor, Kagan, Barrett, and Jackson, asserted, children born in the United States to parents unlawfully or temporarily present are subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment's Citizenship Clause. The opinion emphasized the historical understanding from English common law and the condemnation of Dred Scott v. Sandford, reaffirming that the framers of the 14th Amendment extended citizenship to every freeborn person in this land and that the court would keep that promise today. While the majority stood firm on constitutional grounds, Justice Brett Kavanaugh offered a concurring opinion, agreeing with the judgment but basing his reasoning on federal statutory law rather than directly addressing the constitutional question. The court's three most conservative justices, Clarence Thomas, Samuel Alito, and Neil Gorsuch, vehemently dissented. Justice Thomas, joined by Gorsuch, penned a 91-page dissent, arguing that the majority's historical account was not historically accurate and that the 14th Amendment was intended for persons domiciled in the U.S., not temporary visitors. Justice Alito called the majority opinion a serious mistake, acknowledging its profound historical significance. This division highlighted the deep ideological chasm within the court on this fundamental issue. The Supreme Court's decision brought immediate clarity and profound reassurance to immigrant families across the United States. It prevented the creation of a new, vulnerable class of individuals who would have been born on U.S. soil but relegated to undocumented status, a scenario highlighted by organizations like the Immigrant Law Center of Minnesota, particularly in the wake of Operation Metro Surge. Legally, the ruling firmly upheld the constitutional guarantee of birthright citizenship as established by the 14th Amendment and reinforced by Wong Kim Ark. It decisively reinforced the principle that the U.S. Constitution cannot be unilaterally amended or revised by executive order, underscoring the vital separation of powers. Following the monumental ruling, President Trump expressed his disappointment on Truth Social, calling the decision bad for our country. He suggested that Congress could easily make it up, through legislation, indicating a continued desire to curtail birthright citizenship. However, the Supreme Court's ruling strongly implies that any future attempt to restrict birthright citizenship would likely require a constitutional amendment, a far more arduous and politically challenging process than mere legislation. This case also marked the second significant defeat for President Trump from the Supreme Court during his second term, following a February 2026 ruling that struck down his global tariffs, highlighting the judiciary's role in checking executive power. The June 30, 2026, decision in Trump v. Ibarra was more than just a legal victory for the plaintiffs, it was an affirmation of a core tenet of American identity. It solidified the understanding that the promise of the 14th Amendment, born from a tumultuous post-Civil War era, remains robust and inclusive. The court's ruling ensures that nearly all individuals born on U.S. soil are American citizens, regardless of their parents' immigration status, thereby preventing a fundamental shift in who belongs to the American family. The principle of birthright citizenship, a beacon for generations, stands firm, a testament to the enduring power of the Constitution.